Well, good morning, good afternoon, and evening to everyone joining us today. We're very happy to be joined by Fred Lederer, Chancellor, Professor of Law, and Director of the Center and Legal Court Technology at William and Mary Law School. Assisting to me today is our own Andrea Meyer, who will be moderating our live questions and audience polls. Fred, welcome to our webinar.
Thank you, Damian. It's my pleasure to be here.
Fred, prior to getting into our conversation today, why don't we have you say a bit more about yourself and the Center for Technology.
Legal and Court Technology. So it's my pleasure, ladies and gentlemen. The picture you're looking at is actually a picture of our courtroom called the Mclaughlin courtroom. The picture itself, as you'll note, is a bit unusual because this was the world's first known virtual reality, excuse me, court record. So actually we were doing a full VR operation, and this is the closest we can give you in a single still image. What is now the Center for Legal and Court Technology was officially announced and began operation in August of roughly 1993. And in those days we were called the Courtroom 21 Project, the courtroom of the 21st century today. Our goal then, as it is now, was to determine how to use appropriate technology to improve the administration of justice. And the key word has always been appropriate. What's appropriate? And as we're too fond of noting, of course, if anyone's ever had a strong urge to take a sledgehammer to a piece of technology, the word appropriate has meaning. So what we've been working on for years is how to use modern technology to resolve disputes, whether we are talking about civil, criminal, family law cases, administrative law, and the rest. About 4 years ago, we then broadened what we do to how will courts and lawyers and law firms and government offices use artificial intelligence, the Internet of Things, and other modern technologies. And in fact, what are the legal issues coming out of all of that? And then, of course, the pandemic hit. And having spent years working on how do you use remote appearances and video conferencing, suddenly we were launched into the world of virtual everything. So that's the quickie.
That's the quickie.
I'd also add that one of the things we've been fortunate enough to do is we support what we call the CLCT court affiliates, which are courts in the US, state and federal, also Canadian, and soon for other countries. And we do our best to help them use technology as usefully and inexpensively as possible. Forgive the plug.
No, it's okay. It's fantastic. And it's a very important project. And we're all very grateful that you guys are doing this. So now that we know some more about you, one of the things we always like to do at the start of our webinars is to learn a bit more about our audience. So Andrea, if you could please. Our first poll is who is in our audience today? Do we have judges, any court technologists, court administration staff, integrators, or AV consultants? And please don't all answer at once.
But do please answer.
Yes, absolutely. And we may have some technical difficulties. Oh, there we go. Now
we're up. Yep.
We're seeing a lot of court technologists, a lot of AV consultants, integrators, all of which I'm sure, Fred, you've have a long history of working with.
Indeed.
Good. Andrea, why don't we end our poll? And AV consultants are our winner for the day. So I'm sure that all our viewers today will agree that so far 2020 could be the latest plot to a Hollywood thriller, and not in in a very good way. So, but unfortunately, it's not leaving us anytime soon, and we're stuck with, in a lot of aspects, quite the conundrum. And for the judicial sector, that question really boils down to how does the court provide defendants with due process while providing a safe environment for those participating in the judicial proceeding? This past May, you published an essay titled Thoughts on Remote Appearances and Virtual Hearings, which I would encourage all of our viewers to read. And in your essay, you state that were it not for the coronavirus pandemic of 2020, a court, agency, or an alternative dispute resolution body would be discussing, remote appearances in terms of how to best conduct hearings with one or more participants in the courtroom. So the concept of the virtual courtroom is nothing new. And in a previous life as an integrator, I can recall being asked about this, type of designs 10 years ago. Can you tell us how remote participation in judicial proceedings has evolved over the year?
Well, before you put anything up, for our viewers and participants here, if you're looking at my background, you're looking at what we call the Mclaughlin courtroom at William & Mary Law School. And let us be frank, this is a Zoom backdrop. I'm actually originating out of my home at the moment. But behind me, you see our judges bench. There are 3 panels. Over my shoulder, you see our witness stand. That has a panel. So what are the panels for? The first 3 give us a remote trial judge or 3 remote appellate judges. In our witness stand, not only can we display evidence there, but additionally and critically, we have a remote witness. So the work that we and most other courts and federal administrative agencies were doing was you had a courtroom or a hearing room, and the question was, how would we bring other people into it? And for that matter, Damon, you have a couple of pictures if you want to pull up.
Absolutely.
So you're now looking, ladies and gentlemen, at what we call a laboratory trial. A lab trial is not a real case. It's a case that is often based on a real one. We bring in a community jury if a jury is appropriate. We have a judge sitting. In this case, this is a federal judge, Judge Barbara Rothstein, who was at the time the head of the Federal Judicial Center, the research and education arm of the federal courts. And we are trying an experimental case. So in that picture, you're seeing a remote witness testifying about documents, and our jurors are all watching the documents as the witness testifies. This was a classic illustration of remote witness testimony, and this is, as I say, a little over 10 years old. Meanwhile, by the way, we have a court reporter in front of the judge, and she is producing real-time text transcript in seconds, which are going to the judge, the counsel, and anyone else we wanted to send to anywhere in the world. So this was a classic high-tech courtroom trial. And that's what many of us have been doing around the country and in many cases around the world as well. But that's not the only thing to be done. This was an experimental operation we did. You're looking at 3 federal appellate judges, the U.S. Court of Appeals from the 6th Circuit, and we are doing a remote federal appeal. Now, it's interesting because what we learned in the process is that this court had for some years been doing occasional telephone appeals, but they hadn't done video. And until we'd done this, I think they had a strong concern that somehow video wasn't a good thing. And indeed, until the pandemic erupted, an amazing number of judges and court administrators thought, let's keep this video stuff to a minimum. It raises legal issues, practical issues, and we're judges, we're court administrators, we're lawyers. We're not big on newfangled stuff if we can avoid it. And of course, then the pandemic erupted and the world changed.
There's a quick question that came in that pertains to this picture. Where are the cameras located at these 3 judges' displays?
Very good question, because those 3 judges were appearing from 3 separate courthouses. And each one was at the time using, I believe, a notebook computer. In those days, not augmented by an auxiliary camera. But especially for the integrators who are with us, a small side comment. One of the problems with doing court work is the requirement to comply not only with law, but also with culture. You'll notice that there's a judge to the far left. She was the chief judge and she was supposed to be in the center. And trust me, we heard about it. So it turns out there are a lot of cultural issues along with good technology as well. In our case, as you'll note, we always try to have our cameras directly above, in line with the screen image for the reasons most of you are familiar with. If not, please ask a question, and I'll love to plunge into the topic at length.
Thank you. So you've mentioned that this, this technology was put in place quite some time ago, about 10 years. How has modern technology changed or improved the virtual hearing?
Well, if I can take that apart even for a brief moment.
Sure.
Modern technology has provided us now with what we call either high-tech or technology-augmented courtrooms and hearing rooms. And they've been spreading fairly rapidly throughout the country, although they still remain, if you will, surprisingly limited in number. And perhaps the single best example I can give you, again, pre-pandemic, is the Social Security Administration. The head of Social Security decided quite a few years ago that she should move the agency onto modern technology. And what were paper files suddenly became electronic files. Well, what about their hearings? So we were fortunate enough, we spent 5 years helping to modernize the hearing rooms. But as it happened, a standard Social Security disability hearing, where someone comes in and says, I can't adequately work, often has an expert who's an expert on working and also an expert on medical matters. Suddenly, they didn't have to physically come. They could just come in for 10 or 15 minutes, whatever is necessary, remotely. Government saves a fortune. The proceedings are made even more efficient. And frankly, everybody is pretty much ahead of the game. This is not the equivalent of a criminal death penalty case.
Right.
But most of our cases aren't. So technology has made many things possible. Now, if we go to what happened after the pandemic started, now most of our folks were kicked out of their offices, out of their courtrooms, out of their hearing rooms. They were at home. They were at home often with wireless. And suddenly they were able to appear with or without backdrops, and they could do business. They could have actual motion practice. They could have bench trials. We even, as most of you know, have had one jury trial, along with a couple of sort of jury trials and the like. And all of this was made possible by modern technology.
Now, everyone, during the pandemic has really scrambled to try to get back into some sort of normal business landscape. The first thing we did was completely shut down. Now, has there been an evolution to the virtual hearing because of this pandemic? What are you seeing out there?
Well, of course, what we had first was a rapid move to attempt to take advantage of the technologies in order to at least keep doing some of our business. And then we got better at it. So our court affiliates have an annual conference. Ours was supposed to be hosted in Orlando, Florida by the Ninth Judicial Circuit this past April. Instead, it became virtual. And what did we talk about? How do you use video conferencing in courts in order to make everything work as best we can? In a couple of weeks, I'm going to be speaking on much the same topic before the country's federal administrative law judges. What is their goal? What are best practices? How do we make this work better? And then ultimately, after we survive the pandemic, the question is going to be, how much of this are we going to keep? And how are we going to run what we're going to keep?
And that's a very good point. And every time there's an evolution, there's always challenges. Whether they're we had a sidebar before getting on here where we're talking about just the number of people connecting in one household as being a challenge. What types of challenges are you discovering as you speak with your affiliates out there?
Well, to begin with, of course, we have some fairly fundamental questions about what is it that we should do, not always what could we do, but what should we do with the technology? What actually works? What doesn't work? We have a fundamental problem, and that is, to what degree do we want to mirror reality, pre-pandemic reality, with the technology? So, for instance, in American courts, our courtrooms are supposed to look majestic. Mine is the highest tech courtroom in the world, quite literally, by the way. It's not quite so majestic given the amount of technology we've got it, but nonetheless, when you walk in, you know you're in a courtroom. Well, if you walk into a Zoom meeting with a grid, it doesn't feel a whole lot like a courtroom. Can we make it like one? Yes. Besides cybersecurity issues and who wants to be Zoom bombed in the middle of a court hearing,
Right.
there are questions about, are people free to just show up, or do we want to run it just like a regular courtroom and trial? Everybody gets admitted in the right place, and then we have to wait till the judge walks in or appears. And by the way, do we then stand up? In Australia, by the way, you have to stand and bow to the court. I haven't asked what they're doing on their video conferencing appearances, but how much of this do we copy? This isn't the hard technology stuff, like how do I handle voluminous amounts of evidence? How do I handle, I can't do physical evidence. So, Your Honor, may we please pass the image of the gun
Right.
to the witness and so on. But all those are real issues.
Now, before we get on to the next question, because we really I want to focus in on more of the operational side that we've gotten into. I want to ask our audience, what is your current operational mode for those who are on the court administration side or on the judges or attorneys? So Andrea, if you could please bring up our second poll question. This is something I may have to
question is up.
Okay.
Yeah.
There we go. So is everyone out there 100% remote, hybrid? Are you on site for the most part? And it looks like have a few that are 100% remote, but the most part is a current hybrid style model, which we will get into through our discussion, because it is what I'm seeing out there the most, and the largest request is for that type of model. And we'll give it a few more seconds before we end our poll.
Yeah, while the poll is
I think we may have lost her. She is having some technical difficulties, and I apologize for that. Oh, Andrea, you're back?
Did you, is the audio gone?
Your audio went out, but if you want to ask the question again, because I think
okay. You mentioned a jury trial. Has a court conducted a full-fledged jury trial, or are you referring to a summary jury trial in Texas, or the virtual jury selection efforts in Florida, Indiana, and other locations? Please give additional details.
There has been, in addition to what you're talking about, there has been one real jury trial, which actually did get conducted in Texas. And I'm not referring to the summary trial that you're talking about. There's been one real jury trial. Now, in order to do that constitutionally, the counsel and the defendant had to waive their classic constitutional right to a jury. So what happened is you get a virtual jury, which is probably, almost certainly a constitutional objection if the defendant had wanted to make it. And without identifying the source, I've talked with at least one federal judge whose thought was that it was probable that if the pandemic continued, we would get an increasing number of defense attorneys willing to do exactly that. Meanwhile, as most of our viewers or listeners are aware, participants, we do have courts going back into session trying to go ahead and do social distancing. Sometimes that's moved out of the courtroom in order to have facilities that are big enough. There has been no major move to remote jury trials that I know about. There has been, however, a large move to remote appearances for what we call motion practice, and also apparently a reasonable number of bench trials as well. I don't have any numbers on that. And I can talk about what it takes to do one of those if you want.
Well, it's funny because I did read that in August, this past August, Duval County, which is Jacksonville, Florida, did put together a civil trial that was fully virtual and included a jury as well. Now, when I think of jurors, the thing that comes to mind is really, not just only how you get them on all at once, but really it comes to focus. How do you have a juror who's typically, you have to make sure that they're focused and not falling asleep. What type of mechanism do you put in place for that? Or can you?
I don't think there's an adequate answer to that. In real non-pandemic jury trials, one of the key problems that judges and counsel sometimes have to worry about is keeping jurors up. Years ago, we spent, call it about 4 months, doing experimental work in how do you present evidence of foreign language intercepts in a major terrorism case where you're afraid the jurors are going to fall asleep as they listen to a continuous amount of pick whatever language it was going to be. So this is a major issue. In the summary jury trial in Texas that our question referenced, there was a big thing that one of the jurors disappeared for, I think it was 25 or 30 minutes. One of the problems that's inherent in virtual jury trials is the fundamental nature of a jury. And I don't want to take us too far afield, but one of the reasons our jury system works the way it is, whether you like it or not, goes back to the original English history of it. You get the jury, and the jury has to reach a result. And if they don't reach a result, we keep going. And in the earliest English days, where the judges would, as they put it, ride circuit, they would pack the jury into wagons and take them with the judge to the next location until they reached a result. Today, of course, at some point, we decide we get a mistrial because the jury just can't make up their mind. But there's a world of difference between being almost physically locked into a single room with all the other jurors and sitting there in your living room, your kitchen, or whatever, having a discussion with people who are doing the same thing in their own homes or offices. It may be better, but it's not the same. And that's why, as far as I can tell, we couldn't have mandatory, involuntary, virtual jury trials. It would be unconstitutional.
And then there's the other aspect of sequestering a jury as well. I mean, than some larger, longer cases, there's no way to be able to do that. So before we move on, I want to ask our third poll question, because we really want to discuss the hybrid model, but I'm very interested in finding out what type of video or web conferencing technology do you use today? Is it Cisco WebEx, Microsoft Teams? Are you on Polycom, Zoom, or some other form of video conferencing? And as expected, Cisco, Microsoft, and Zoom are probably our highest, with Zoom being the most popular solution today. Now, I know you have some thoughts on Zoom regarding security, and we will get into that. But Zoom, for the most part, over half of our audience today has been using it. Now, pre-pandemic, there was, in terms of technology, there was a very standard approach, very similar to what you have in your background up on the screen. Now, typically looked like something that I'm showing right now, which was you had displays at the judge, the attorney, you had connection points at the lectern. If your technology was put in place in the last handful of years, you probably had wireless connectivity, and then it all was displayed accordingly throughout the courtroom on jury screens and large panels on the wall. Now, rather than pursuing a fully virtual approach, would it be a more viable scenario to really look at a hybrid approach where maybe the judge and the jury are sitting in the courtroom, and then the attorneys are coming in from their respective offices and having the defendant, if they're jailed at the time, if it's a criminal trial, coming in from a secured facility?
Well, we start with fundamental legal and constitutional issues. So if we're able to have a jury physically present, it's going to be very hard to argue that the defendant in a criminal case and the defense counsel don't have to be there or won't be there. So almost certainly, if we're going to do a jury, we're going to have people physically in the courtroom as well. But it seems almost absolutely certain that we are going to go ahead and use a hybrid model to an amazing degree post-pandemic. And although it is always fascinating to think about criminal jury trials, the simple fact is that, number one, most criminal cases and most civil cases don't go to trial at all. And if they do, they don't go to jury trials. They go to bench trials. And if you think about it, if I were building a courthouse, and we of course advise constantly to courts that are building courthouses and such, you figure that most of your work is not going to be actual trials. It's going to be work related to those trials, whether it's motion practice or it's alternative dispute resolution, pretrial settlement, and the rest. So what makes the most sense? Well, the model that's been followed increasingly by federal administrative agencies has a hearing room. It's got a judge in the hearing room. The judge has the equipment. There's IT support. We have decent connectivity. And then other people, as appropriate, come in from the outside world. If you're going to use COVID concerns, obviously this keeps the judge safe, but it also means the judge does have proper bandwidth, proper hardware, and often, though not always, proper support. One of the things that's come out of some of those experimental jury trials, and for that matter, it comes out of our experiments with virtual bench trials, is you got to have somebody who's going to run the technology. Right. You have to have somebody who's going to play the bailiff, the usher, the emergency tech support. In the summary jury trial in Texas, they had a second judge who did that. You can't have the judge worried about, what do I do now? You have to have somebody else who does it. And that's one of the problems. That's why increasingly we're looking at third-party vendors who are now going into the virtual hearing business. I know of at least 3 companies, 3 of our participating companies, as WolfVision is, that are competing with each other in that space, because most of our courts are not set up for that degree of technical support.
So for those viewers out there who are unsure at what the initial steps that they should take for preparing their courtroom for some sort of suitable hybrid model, and one of the things that you said, at the onset of this webinar was that, do what you're capable of, but not try to replicate the exact model of an in-courtroom perspective. So what would you say are the first steps, or what is a standard practice model?
What we do, and I assume everyone else who's ever been in the same space, particularly your integrators, always has to do, you have to go ahead and do a systems analysis. You have to figure out what the goals of your client are going to be. We do short, midterm, and long term. One of the obvious problems here is this. You can attempt to design a system that can do anything. It's improbable most courts could ever afford that anyway. But from our perspective, we would ask, what is it you most want to be able to do that is practically possible? And then produce a design that will handle that. And if it turns out that we can build onto that design as the court's abilities and goals increase, that's great. But in our experience, obviously, the single most critical step is always infrastructure. In this particular area, the infrastructure issues are fairly apparent. If nothing else, we have to have dependable bandwidth. And what we were working on until the pandemic blew up, and had spoken with you in particular, is we have to find a way to make what we do much less expensive and much less technically complicated. So we've been heading toward what we've called for some years the courtroom in a box, which is basically a secure Wi-Fi environment where we don't have to worry that the signal is going to bleed out beyond the room. We connect our equipment, if necessary, by Wi-Fi into the backbone, which is almost always copper. Excuse me, heaven forbid, not copper, by glass. And we go from there. Now, if we're doing a pandemic or post-pandemic, obviously we want to avoid Wi-Fi if we can. But increasingly, the places we're going to have to put hybrid facilities are likely to need some type of Wi-Fi based local distributed network, which, just to give WolfVision a free plug, along with some of the competitors, you folks do very well.
I was going to say, I think I know of such a device. And, prior to, COVID, the trend, was BYOD, and everyone was pounding the point, let's connect wirelessly. But as, trends come and go, it seems like the new trend is really more of a touchless AV solution where not only do they want to wirelessly present, but they want to avoid having to touch other touch screens and points of contact where bacteria may live. What is, when you think of a completely touchless AV solution, what comes to mind?
I don't think that we know enough from CLCT's perspective. You folks might, but I don't know that we know well enough what to do because we haven't had an experience to try it. Our experience over the years, what makes us who and what we are, is that we're a pretty much unique combination of technology, law, and human beings. And what most of the people who are participating with us undoubtedly have learned is that when you add real human beings into the mix, things don't always work the way we planned. And lawyers and judges are particularly in that group. And we do know the single most effective technological solution is not always the right one given the culture. Too many war stories about things like that. So we don't know. We're going to have to try to experiment. And of course, right now, we're not even back in our own courtroom due to the pandemic. So much for experimental work.
Right. Right. And then there's, beyond those challenges, there's you've mentioned the challenges of wireless in terms of bandwidth, but in the early days of wireless networking, one of the biggest challenges we had was simply security. And, one of the first security issues we came across, through this pandemic, Zoom bombing. So with security always a concern for courts, obviously, what should our viewers be aware of regarding security and specifically wireless presentation security and video conferencing security?
The dilemma here is this. While we know a fair amount in CLCT about the law and cybersecurity, we're not hands-on cybersecurity experts. Pretty much everybody who was paying any attention to news broadcasts, newspapers, or the internet equivalent when the pandemic hit us realized that according to numerous sources, Zoom was not secure.
Right.
And for many different reasons. Zoom has gone through a number of security upgrades. I lack the personal ability to evaluate those upgrades. Pragmatically, the question that has always faced us is not the one that faces most businesses. Under normal circumstances, very few people have an interest in penetrating a trial or a motion argument. There's no economic gain because these have traditionally been public. You could just as well sit there. Now, Zoom bombing, of course, is a whole nother thought. Are there people who would want to come in to disrupt things? Absolutely. So do we want to attempt to minimize the possibility that people will interrupt the proceedings? Yes. What is the largest concern? The largest concern is that somebody will use our technology as an entry point into a courthouse network or something like that. When we teach our artificial intelligence and cyber everything course, we try to explain to people, and some of our folks will undoubtedly have seen this. There was a story that hit, I guess it was now about 3 or 4 years ago, about a large but unidentified casino that was hacked. How was it hacked? It turned out that one of the employees had a lovely aquarium, and the aquarium had a network connected temperature gauge, among other things, in the tank. That's how they got into the network. So from a classic cybersecurity perspective, first and foremost, we don't want to be the entry point to someone who wants to hack the courthouse, if only for ransomware. No.
A few quick interruption, a few questions from the audience, if that's okay.
Absolutely.
One is, it seems like remote witness testimony is and will be the most utilized technology. Any tips on conducting this optimally?
I'm happy to discuss that with whoever asked the question independently if he or she would like. We've been doing remote witness testimony literally for years. What we have learned is this. We did with the help of the William Mary Psychology Department, we did 2 years worth of empirical experimental work, which unfortunately was never published by the professor involved. What we are fairly confident of is this. If you have the remote witness physically located largely where the human witness would be, and if you look over my shoulder, just raise the hand, you'll notice there is the large monitor, flat panel, that's right behind the witness stand. So if we have a remote witness testifying, as you saw when we put the slide up earlier, that person is life size and is almost exactly where a human being would be. If that person is located life size in that location, and we have sufficient bandwidth, so we do not have delays or anything else, the experiments that were done indicate we got a jury verdict that was pragmatically the same, whether those people were remote or were physically present. Now, beyond that, we have lots of other issues. So at the other end, we need, of course, to have the camera in the right location. Just as in our courtroom, we have to have the camera in the right location, and you can't see it here. But the witness camera for the remote witness is located in line in the center, right above the flat panel, in effect, although we have ceiling-based cameras and such. So otherwise, you get very, very bad results. And so I can go on at length, but I'm not sure that's of interest to others. I'm sorry.
Yeah, we can also pick that up offline. So there's another question. When considering the possible long-term integration of virtual technology, how do you imagine this would impact the operating expenses of the courts?
It's going to depend on which budget you want to look at, and I'm not being silly. One of the things that's become apparent is if we can move a significant amount of the court business out of courtrooms, we need fewer courtrooms. That means we have a capital savings. We don't have to build a brand new courthouse because we're out of space. We don't have to potentially renovate courtrooms and so on. So we have that. Then we have other matters which get us into a little bit more complicated. Let's talk about a classic high-tech trial of the type we showed you in that slide. The generally accepted numbers are, which have not been confirmed, as I'll explain in a minute, is that high-tech trials, largely meaning visually presented evidence, are roughly 1/4 to 1/3 faster than trying the same case traditionally with paper. We have two judges, one from Australia and one from the US District Court in Oregon years ago, who in major cases estimated a 50% time savings. In our own experiments, in a ridiculously simplistic 1-hour civil jury trial with approximately 6 exhibits, we had a consistent time savings of approximately 10%. Now, when you start looking at those time savings and you figure out that means we can do more work in less time, fewer courtrooms and all the rest, we get immense savings, personnel as well as capital. And by the way, as best we know, we do a better job in reaching justice. Sorry for throwing that in.
All right. Andrea, do we have any more questions?
Yes, we have one more. It was, are you familiar with the online courtroom project task force conducting a 2-day full virtual jury trial that involved the, I hope I pronounce it right, voir dire process? I believe it was on June 26th.
I'm not familiar with the specific project, but we've certainly, there have been particularly grand jury qualifications and such done in that fashion. Voir dire, which is taken from the French, and we all mispronounce, including me as a rule, is the process of questioning jurors. And in fact, I'll be teaching my one of my classes the next semester how to do that remotely. So this is whether we do this for trials, civil or criminal, we do it for grand juries, which has been done. The question here is, do we really have to make people come into the court just to find out if they're going to meet the qualifications? And of course, what I can tell you is defense attorneys, and for that matter in criminal cases, prosecutors as well, or counsel in the civil case, tend to be acutely unhappy with doing this because they believe they have the ability to evaluate jurors, or in the case of the prosecution, grand jurors, based on body language and the rest. I can tell you that scientifically, it turns out that judges and jurors really can't tell when people are telling the truth or not. That doesn't stop them, however, from believing firmly that they can. And that was currently what's going on every time there's a discussion about jury selection remotely.
Very good. Before we get back into some questions, I'd like to go to our fourth poll of the day, which is regarding our previous Touchless AV subject. We like to know, is Touchless AV very important for you, somewhat important, or not important at all? And by the looks of it, it seems like there's mixed reaction to a purely touchless AV system, with some importance for some and not much importance for others. So thank you, Andrea. So back to our questions. I think when we talk about technology in the courtrooms, beyond the challenges that tech can provide, there's always the challenges that us as humans bring to the table. And that's due to lack of training. And I'm not sure how familiar you are with the Ninth Judicial Circuit in Florida, which is up in the Orlando area, as you know. They have a fantastic training program for their attorneys that their judges require in order for the attorneys to even practice law. And it's really geared towards using our sign-up solution so that when the attorney comes into the courtroom, they're at minimum familiar with the steps to take to get connected and present in the courtroom. What do you typically recommend for your affiliates in regards to the training process?
Well, the Ninth Judicial Circuit is our founding state court affiliate, as it happens.
Okay.
We've been working with them, and particularly their famous court administrator, Matt Benefield, for years, and their chief judge. As a rule, most trial lawyers don't know how to use trial technology. So first, someone has to train them, and that can't really be the court and shouldn't be the court. We actually have a whole set of what we call the protocols now under revision for courts and for trial lawyers as to what's the responsibility of the lawyers, what's the responsibility of the court, and the Ninth was part of that original project. You can't have the court train the lawyers, because then the claim will be, gee, the courtroom technologist who did the training favored one side of the case over the other. However, it is utterly essential that the court advise the lawyers as to what its rules are, what the technology that the court is making available, preferably free of charge, is going to be, and allow the lawyers to come in and set up and be sure it works, or decide what to do if it doesn't work. Because otherwise you get into trouble. Now, there are any number of stories, which depending on your perspective are hilarious or tragic or both, about the problem with lawyers. And if we have time, may I tell one of them?
Absolutely, please.
So I won't identify where this came from, although all of you would recognize it instantaneously. So the story goes this way. We have a lawyer goes into a high-tech courtroom who thinks he knows how to go ahead and do a high-tech trial. He connects a notebook computer to the courtroom audio-video distribution system. He knows his computer works because it's up and he's watching it, but nothing is showing anywhere in the courtroom. He is rather indignant. He announces to the trial judge, "We're not yet at trial, we're about to be. Excuse me, Your Honor, but apparently there's something wrong with your courtroom." And according to the story as it was told me, since I was not there, the bailiff solemnly, but apparently laughing inside, walked slowly forward, stood next to the lawyer's computer, took his fingers and went boom, pressed the key combination that told the computer to output its video signal, and suddenly everything came up. And then he simply returned to his place without saying a single word, leaving, I hope, an incredibly embarrassed lawyer. Now, that's, when we train lawyers, and not only we design courtrooms all over the world and we train counsel, that's one of the things we cover. And we also tell them if they're smart, they'll pretend they're pilots. They'll have a short list of incredibly simple stuff that we tend to forget. This is not the hard stuff. It's the little stuff that stress means you're distracted from and you forget to do.
And those are typically, those are typically the challenges. It's the small things. We've seen it all, right? People forget to connect their power. Why isn't it working? Well, did you turn it on? Go ahead, Andrea.
Yeah, there's a question that kind of goes along with this regarding the earlier discussion regarding the training. Somebody's asking, are self-represented litigants taken into consideration when designing these high-tech courtrooms?
Short answer, yes, at least if they're being done by anyone who's competent. The problem of self-represented litigants or unrepresented litigants, which is closer to the mark, is a huge matter. Just to note, for instance, I'm part of a Virginia Supreme Court committee that deals expressly with that issue. It's of such importance to the Virginia Supreme Court. And it's an incredibly complicated issue, as most of you who are participating here know. But one of the peculiar things that has happened over the years is two loosely related things. Number one, an unrepresented litigant may be more technologically capable than the lawyer. And that tends to invert things. But secondly, where the design issue becomes fundamental, is an immense number of people in general, but particularly unrepresented litigants, will come into the courthouse if they are permitted, which is a whole nother painful administrative issue, with their cell phones, with their smartphones, and they're going to tell the judge, Your Honor, all my evidence is on my phone. Now what do? Do I bring it up and hand it to you? So when we design courtrooms these days, we are always designing it with the ability for a individual, whether it's a lawyer, a witness, or an unrepresented litigant, to go ahead and display into the courtroom's display systems from a smartphone at minimum. And of course, today, as everybody knows, it's humanly impossible, it seems, for something to happen without somebody pulling a phone out.
Right.
So this is one of the things that drives high-tech courtrooms. In the old days, if you might have to hire a consultant. Today, everybody has high-tech evidence. You don't have to have police body cameras or sedan cameras to have video, audio evidence. Sorry.
And then, well, and that brings, the importance of being able to display that evidence more importantly, because it's not your traditional laptop. No one brings anything on a drive or even a CD. Everything is, as you said, BYOD related technology, which is great because, again, I happen to know of a device or a set of devices that show that. And before we end today, I do want to let everyone know that you will be getting more information on WolfVision product regarding today's webinar, in particular our Synapse product family, which can remedy or allow an avenue of to display, be able to stream, be able to segregate your jury or space them based on CDC guidelines, 6 feet apart. So we're not talking about it directly today very much, but you will be receiving more information. Now, before we conclude with our last question, we do want to have our last poll of the day. And that poll, Andrea, please, if we want to know, are you looking to make any changes to your evidence presentation and collaboration technology due to COVID-19? And as we see our yeses and nos and those who are unsure, we are seeing a resounding amount of yeses out there, which we're happy to see. And I'm sure integrators and consultants out there are very happy to see as well. Now, before we cut off, Fred, I do want to ask one more question, and it's regarding the use of technology. And how will the use of technology during pandemic likely affect how courts and lawyers continue to operate after the pandemic?
As I've said before, we have what apparently is near universal agreement that some of what we're now doing will survive the end of the pandemic. And that's not just because it saves money for courts. The example that we are prone to using is traffic court. Why should an individual who's gotten a traffic ticket of some type have to give up a half a day or a day to go to court for what's often a 15-minute hearing? Now, there have been experiments done in prior years. One was done in Arizona, for instance, with doing remote minor cases. But increasingly, we've now proven we can do this. It's amazingly simple to do a basic bench trial with modern technology. So, since we now have so many judges and court administrators who have learned it's not that hard, and so many lawyers to discover, gee, I can competently do this, logic is going to suggest that we're never, ever going to go entirely back the way we were. We're likely to have, how many lawyers are going to want to go take a large city environment and drive or take public transportation to a courthouse, clear security, and go to a courtroom where there are another 50 or 100 lawyers waiting for a docket call, or for a simple motion when we can do that from your desk or even from your car.
Right.
We're just not going to go back. And if courts want us to go back at that level, I think there will be a sufficient amount of public pressure to stop that. And judges and court administrators care about not just justice, but serving the public and the bar. Very few of them are going to want to do something when we can do something better, easier, and cheaper. It helps us all.
You're right. So we do
So
have
there are
some time.
several more questions.
Yeah.
Yes.
We do have some time for a few more questions. And
So, yeah, sorry.
if we don't get to all of them, we promise we will respond directly to your questions after the webinar.
I can
So
stay on if that's possible, but
Yeah.
as you prefer.
Do you envision all courtrooms will need to add more of a technical bailiff or additional court staff, non-IT, to address technical issues in the courtrooms?
No, if only because we're not going to, it will take a long time if and when we ever fully equip all courtrooms for full technology. Furthermore, court budgets won't afford that type of staff in many cases. Again, staffing becomes a more complicated question. The Ninth Judicial Circuit does it one way, everybody else tends to do it differently, for instance.
Right.
So what we're probably going to find is we're going to bolster the number of people who can troubleshoot and support. And my own thought has been, we've not talked about court record. A year ago, we did we unveiled what I think is the world's first artificial intelligence-based automated court record. And if I'm right, that is unfortunately in some ways going to make court reporters obsolete. And I'm very hopeful that many of them will become courthouse and courtroom technologists who will support because they're perfectionists, they're really good people, and they can be a special type of expert who will assist, but not one per courtroom. We have one more question.
It's just a note from somebody. There is a online courtroom project, onlinecourtroom.org. Are you familiar with that, Fred?
I was asked and I'm not, but I'll be looking it up.
Okay, yeah, that's something we can all look at. And then there's more of a question about Zoom interpretation. Somebody states it helps but does not work with room systems. So any experience on your side with Zoom interpretation?
We have done a huge amount of work with remote interpretation. We may even have a picture. I had sent one, but we've not used Zoom. Now, there shouldn't be a major problem unless we're having, it's important to know whether we're trying to do consecutive or concurrent. Concurrent would almost certainly present a huge issue in Zoom. Consecutive ought to be fairly simple.
Okay, I think that covers the majority of the question. Everything else will be addressed offline.
Fantastic. Well, everyone, thank you for joining. We saw that a lot of you were on with us today, and stay tuned because we will continue this series of judicial webinars through the end of the year and into the new year. Fred, thank you again. And Andrea, thank you.
My pleasure, and thanks to all of you who attended.
So long, everyone.
Goodbye, everybody.